Don't let your ex-spouse undo your wishes. Here's how to lock them out legally. First, let's make sure they're actually an ex and not just separated. Legal divorce, the actual dissolution of a marriage, cuts off inheritance rights from you and your ex-spouse. But if we're only separated and there is no separation agreement that is otherwise waiving inheritance rights, your ex is now still legally your spouse. And so they may be entitled to a substantial portion of your estate if you hadn't otherwise disinherited them. North Carolina has the elective share statute, which allows a surviving spouse, even if you're separated, to petition for between 15% and 50% of your gross estate after you've passed away, depending on the duration of your marriage. The divorce decree itself, an actual dissolution of marriage, is what terminates that inheritance right. Alternatively, if you haven't yet been divorced but are separated, make sure we get a separation agreement that does waive all inheritance rights signed as soon as possible. The second is making sure that our beneficiary designations have been up to date. A divorce decree does not change your 401k, IRA, and life insurance designations. So if you are separated or divorced, we want to make sure that your ex-spouse is not named on those beneficiary designations, because if you do pass away, they will get the share that you've otherwise given to them, even if you didn't intend it, even if that was just by mistake. The beneficiary designations don't care. And third, and probably the most obvious, is if you're creating an estate plan after you've been separated or divorced, do not name your ex-spouse in any fiduciary roles like trustee, executor, or agent, or as a beneficiary to receive part or all of your estate. That should be clear. We've seen weirder things. If you are a single parent who is divorced and have a minor child, it's also important to not name your ex as the trustee of your trust or executor of your estate over your minor child's share. While it won't go directly to your ex-spouse, it will roundabout, because they'll still be the guardian of your child. And until the child is 18, there will be some coordination of asset transfer through your ex-spouse. So all of these roads lead to the same outcome. Use an experienced estate planning lawyer to make sure that your estate plan is going to do what you want it to do, not what your ex-spouse wants it to do.